Good morning, Mr. Sharif. How are you doing lately?
Good morning. I'm doing fine, thank you. I hope you're doing well too.
Glad to hear that, Mr. Sharif. In our recent phone call conversation, I recall that you have some matter that you would like to consult with us. I have gathered my legal associate and people to hear your situation. This is Siti Hazira, our legal associate, and this is Anusha, our pupil.
Hello, good morning, sir.
Nice to meet you, sir.
Mr. Sharif, do you mind explaining the situation which you mentioned during our phone call? Please feel free to share it with us.
Good morning, everyone. Thank you for meeting with me today. I appreciate your time and willingness to assist me in resolving this matter. As you know, I recently filed my petition to the High Court in Ipoh to be called to the bar. It has always been my aspiration to practice law, especially after serving in the police force for decades. After my retirement, I saw this as an opportunity to use my skills and knowledge to contribute further to society, this time in the legal profession. However, I find myself in a very challenging situation. The Majlis Peguam Malaysia, supported by the Perak Bar Committee, had raised an objection against my call, claiming that I am not a fit and proper person. Their objection stems from an incident that occurred several years ago when I was the deputy OCPD of Brickfields. At that time, there was a candlelight vigil outside the Brickfields police station involving members of the public showing support for human rights activists known as Amoeba. 8 lawyers from Mubah Council Legal Aid Centre were present to provide legal assistance and they were arrested. I understand that this incident caused significant concern and Suhakam conducted a public inquiry. Unfortunately, the findings in their report were critical of me. The inquiry concluded that my evidence was totally unsatisfactory and implied dishonesty on my part. And this report has now been used as a basis to question my integrity and suitability to join the legal profession industry. I admit that this incident was very contentious and it is disheartening to see it resurfacing now. At the time, I acted in my capacity as a police officer carrying out my duties as I understood them. If mistakes were made and they were not intentional and I never sought to undermine the legal profession or the rights of individuals, with that being said, I am deeply troubled by the allegations of dishonesty and lack of cooperation during the Suhakam inquiry. I wish to assure you that I have always upheld integrity throughout my career. The perception created by the inquiry's findings does not reflect who I am or my intention. So today, I have come to you seeking your guidance on how to address these allegations and demonstrate that I am indeed a fit and a proper person to be called to the bar. I want to present my case truthfully and transparently, highlighting my years of service, my commitment to justice, and my willingness to rectify any missteps. Would you please advise me on how I should proceed? What steps can I take to address the concerns raised by the Majlis Peguam Malaysia and restore confidence in my character and integrity?
Hello. I have a question to ask Mr. Sharif. Do you believe that your act as a deputy or CPD is dishonest act?
Hmm. I admit that the incident was contentious, as I mentioned, and it is very disheartening for me to see that it is resurfacing now that I am applying to be in a legal profession industry. As I've said just now, at the time, I acted in my honest capacity as a police officer carrying out my duties. The mistakes made, they were not intentional, and I never sought to undermine the legal profession or the rights of individuals. I deeply regret any misunderstanding during the Suhakam inquiry, and I respect their findings, though I believe some aspects of my actions were not fully understood.
Mr. Sharif, while I appreciate your explanation, Suhakam's finding raised significant concern about integrity and accountability, which are the essential qualities to the legal profession. We will consult among ourselves on this matter and get back to you. Thank you.
Um, all right, thank you, and I'll be looking forward to hear from you soon.
Hi everyone. Since we have agreed to discuss the relevant authorities regarding Mr. Sharif's situation, let's begin with the discussion. Anusha, as I instructed you last week to do the research work, may I know what you have found and can you present your finding to me and Miss Hazira?
Yes, Madam Alia, I've prepared according to what you have instructed me to do, and actually came up with two issues based on the facts presented by Mr. Sharif to us during the first meet with him. So, as for the first issue, it's whether Majlis Peguam Malaysia can file a notice of objection and a caveat against filing of long call papers by Mr. Sharif. And second issue is whether Mr. Sharif can still apply for long call papers after caveat release. So as for the first issue, when we look into the Legal Profession Act 1976, under Section 16 and under Section 17, the Majlis Peguam Malaysia actually has a right to file for notice of objection and a caveat to the long call papers of Mr. Sharif. So Section 16 of the LPA, it states the procedure to file for an objection, and it clearly shows that a notice of objection can be filed, and in Mr. Sharif's situation, Majlis Peguam Malaysia can file a notice of objection to the long call papers of Mr. Sharif. So in Section 17 of the LPA, it states that anyone may enter a caveat against admission of any petitioner. In the situation of Mr. Sharif, Majlis Peguam Malaysia entered a caveat on the long call papers of Mr. Sharif, and it is allowed by law. And these sections were also cited in the landmark case of Majlis Peguam Malaysia against Judy Blasius, son of A.F. Pereira. As in this case, the court did interpret on Section 16 and 17, showing that anybody that is in charge of admitting a person as an advocate and solicitor has the right to file a notice of objection and a caveat on the long call papers of such petitioner. So, Madam Ali and Ms. Hazira, if you do not have any queries on the first issue, may I proceed with the second issue and what authorities I actually cited for the issue?
No, Anusha, you may proceed.
You may proceed, Anusha.
Okay, thank you, Madam Ali and Ms. Hazira. So as for the second issue that I've gathered from the facts given by Mr. Sharif is whether Mr. Sharif can still apply for long call papers after caveat is released. So here, I actually found the case of Majlis Peguam Malaysia against Judy Blasius, son of A.F. Pereira, where in this case, the Court of Appeal decided to dismiss the notice of objection and caveat and ordered that the petitioner to attend 8 hours of any cost forums programs conducted by the Human Rights Committee of the Malaysian Bar for 3 months. So upon completion of this, then only the petitioner will be called to the bar. And here in this case, they also argued and the court has the right to give such orders under Section 10 of the Legal Profession Act to admit the petitioner as an advocate and solicitor. And the Court of Appeal in this case stated that the High Court didn't exceed their right to admit the petitioner by imposing such orders to them. So after caveat released, Mr. Sharif can actually apply for his long haul papers and be admitted as an advocate and solicitor. However, if the court has given any sort of orders to Mr. Sharif similarly to what has been ordered to the petitioner in the case of Judy, then Mr. Sharif is expected to comply with the order by the court before applying for his long call papers. If Mr. Sharif fails to comply with the order, his long call papers will be rejected with the reason that he disrespected the courts as held in the case of Judy Blasius, where it's Bar Council Malaysia's case against Judy Blasius. So that will be the issues that I found from what Mr. Sharif told us, and this will be my findings on the cases, Madam Ali and Ms. Hazira.
Okay, good. I have no questions regarding your presentation, but perhaps Miss Hazira would have something to comment on the presentation. Miss Hazira, do you have anything else to add?
Oh, Mida Alia, I have something to add on to Anusha's presentation. Anusha, from what you have presented, I think we can add another issue which is on the whether Mr. Sharif is not a fit and proper person to be called to the bar due to being dishonest and not giving full cooperation during public inquiry when the petitioner was the deputy or CPD for Breakfast. Under this issue, we can include Section 3 of the LPA, where it gives an interpretation of qualified person is someone who meets specific criteria set by the law. These include individuals who have passed the final exam for a Bachelor of Law degree from universities such as University of Malaya, University of Malaya in Singapore, University of Singapore, or the National University of Singapore. It also includes barrister at law from England. Additionally, the term can apply to anyone with different qualification that the board officially recognizes as sufficient through a gazette notification. This ensures that a variety of legal this ensures that a variety of legal professionals can be considered qualified under the law. And Section 11, Subsection 1B of the LPA state that a qualified person can be admitted as an advocate and solicitor subject to Section 14 if they are a good character. This includes not being convicted of any criminal offence, especially those involving fraud or dishonesty that will make them unfit for the profession. Additionally, they must not be declared bankrupt or found guilty of misconduct as outlined in the Bankruptcy Act 1967, ensuring that only individuals with strong ethical and professional standards are admitted to practice law. Even though he already complied with Section 3 and Section 11, Subsection 1B of LPA, subjectively, Majlis Peguam Malaysia also needed to evaluate the character of the person to be called as an advocate and solicitor. Cases that we can refer to is Tavanathan, anak lelaki Bala Subramaniam against Majlis Peguam Malaysia. The court held that the issue in determining sanction to be imposed on the appellant will be looking on whether the misconduct committed by the appellant was serious or otherwise. In application to Mr. Sharif's situation, it has shown that the act of Mr. Sharif as a deputy or CPD being dishonest and not giving full cooperation during the public inquiry by denying that he interacted with any lawyer until he was confronted by the documentary and strict direct evidence that show otherwise. It has affected his integrity and honesty as a person to control the administration of justice. As we all know, the function of advocate and solicitor and the police officer have the same point of view, which is to control the administration of justice. This situation has triggered the question on whether Mr. Sharif was a fit and proper person as Section 11, Subsection 1B require an advocate and solicitor to be of good character before being admitted to the bar.
Ms. Hazira, I have also read a case on fit and proper person, which will be the case of Re SRC Augustine. This case was cited in Judy's case to explain on good character. And in SRC Augustine, the main issue they were arguing on was on good character. And they stated, here the court stated to see whether a person is a fit and proper person, the petitioner has to give certificates of his good character, which is given by his practitioner to him to show that he is of good character, establishing that he is fit and proper to be admitted as an advocate and solicitor. And the case of SRC Augustine was actually a far more serious case compared to Judy's case. And however, but in SRC Augustine, the petitioner was still admitted as an advocate and solicitor due to the decision and order of the court. And basically, in this case, the order of the court was the petitioner has to give certificate to show that he is of good character. And since in this case, the petitioner did give such certificate, he was admitted as an advocate and solicitor.
Okay, great work with the presentation, guys. Miss Hazira, I think you can call Mr. Sharif to come to our office tomorrow so that we can start advising him with all the authorities we gathered.
Okay, Madam Alia, I will make an appointment with Mr. Sharif.
Before we begin our session, I would like to inform you that the advice given by us is based on the facts provided by yourself and our knowledge pertaining to this issue. There are three parts to this discussion, which are on the qualification for admission, validity of Majlis Peguam Malaysia's objection and caveat, and lastly, filing of the long call papers.
One of the issues is on qualification of admission. Referring to Section 3 of Legal Profession Act, I fall within the definition of a qualified person. And I also satisfied the requirement under Section 11, subsection 1, para B of LPA due to the fact that I am of a good character and honest person.
As to how we can determine someone is of good character, we can refer to the case of Re SRC Agustin. It explained the main issue regarding good character and to see whether a person is fit and proper. The petitioner has to give certificate of his good character given by his practitioner to show that he is of good character, establishing that he is fit and proper to be admitted as an advocate and solicitor. Based on our finding, the principal in the case of Tavanathan Analaki Subramaniam NPP elucidate that although the person has committed a misconduct outside of the legal profession, they will be treated similarly with advocates and solicitors as they are within the legal service. This is due to the fact that the nature of police officer and advocate and solicitor is for the administration of justice. Although you acted dishonestly when you were a deputy OCPD and you were not a practicing advocate and solicitor at the time of the commission of the offence, the seriousness of the misconduct has doubted your integrity and honesty in becoming an advocate and solicitor. Moving on, the validity of Majlis Peguam Malaysia objection and caveat. You mentioned previously that Majlis Peguam Malaysia filed a notice of objection and a caveat against the filing of your loan court paper. Applying Section 16 Sub 1 LPA, the filing of notice of objection is valid and you cannot raise any issue towards it unless they do not comply with the period of filing such notice. Referring to Section 17 Sub 1 LPA, Majlis Peguam Malaysia has the right to enter a caveat against your admission as provided under this subsection. Lastly, the filing of the long court papers. As in the case of Majlis Peguam Malaysia and Judy Blasius, sons of A.F. Pereira, the court has the discretion of the petitioner to fulfill any course, forum, programs conducted by the Human Rights Committee. If you fulfill this requirement, you will then be qualified to be called to the bar and admitted as an advocate and solicitor. However, this requirement is up to the discretion of the court and it is not automatically granted. This is in line with Section 10 of LPA. The fact of this case are similar with your situation. In raising an appeal towards the objection against the filing of your long call paper, I would suggest you to bring the court's attention to this case. I believe I have addressed everything that we have looked into concerning your matter. I hope that our session today is beneficial and helps you in making a decision on further action that you can initiate.
Okay, thank you for your time and guidance. I really appreciate the insights that you have shared today and the clarity that you have provided on the concerns raised. This session has been very helpful for me in understanding the steps that I need to take to move forward. I will reflect carefully on our discussion and I will take the necessary actions accordingly.
We understand that you are in a challenging situation. Please know that we have tried our best to provide our assistance. Whatever the outcome of this case, I hope you can move forward in the legal fraternity.
Thank you, Mr. Sharif. We'll try our best to provide you with best legal service throughout this whole case.
Mr. Sharif, if you need any further guidance or would like to give in relevant document to support your argument on this situation, do drop by our office at any time you want. And if you need a consultation with the lawyer in charge, you may book an appointment with us.
Yes, Mr. Sharif, please do not hesitate to visit our office and contact us if you decide to get further clarification on your issue.
All right, I understand. I sincerely appreciate your time and the thoughtful discussion. I will review everything we have talked about today and take any necessary steps to address the concerns raised. Thank you once again for your guidance and support. Have a nice day, everyone.
See, Mr. Sharif, I will guide you out of the firm now.